Welcome back. In this and the next segment, we will focus our attention to another legitimate restriction to freedom of expression, the so-called incitement speech. To do so, we will first review the various provisions related to incitement speech, but also related to its close cousin called hate speech, because both provisions on incitement and hate speech may be brought together under the same provision. We will discuss those various provisions, what they mean, and their differences, if not contradiction. We will then briefly discuss how regional conventions and national systems have addressed incitement and hate speech, focusing in particular on the US First Amendment. And we will end this segment by trying to make sense of this very difficult and imprecise area of law. I will propose and present a possible ways to conceptualize these different kinds of restriction to freedom of expression. To begin with, I should warn you that there is no international definition of what constitutes hate speech, but there are definitions of what constitutes incitement speech. However, under international human rights law, it is quite common for incitement and hate speech to be brought together, not always in the most reasonable fashion, under the same article. Anyway, let's look at those provisions. Under international human rights law, those two forms of restrictions to freedom of expression, incitement and hate speech, are addressed by, and this is shown on your screen, the Genocide Convention, the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, Article 20, and Article 19. And then in a post-9/11 world, some form of incitement and hate speech may also be addressed by the anti-terrorism and anti-extremism resolution issued by the UN Security Council. That's Resolution 1624, calling upon states to prohibit incitement to terrorism. Again, let's begin with the oldest of those provisions, that's the Genocide Convention that was adopted in 1948, and you can see that on your screen. Article 3 states that the following act shall be punishable: genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, and then attempt to commit genocide and complicity in genocide. So the Genocide Convention prohibits direct and public incitement to commit genocide. That is an expression of hatred, and more than that, it is an expression of incitement. Here the key words in the Genocide Convention are incitement, but also direct and public. Let's now look at Article 4 of the International Convention Against Racial Discrimination. It has fairly extensive articles, according to which, and I cite, but it's also on your screen, state parties condemn all propaganda and all organizations which are based on ideas or theory of superiority of one race or group of persons of one color or ethnic origin, or which attempt to justify or promote racial hatred and discrimination in any form. State shall declare an offense punishable by law all dissemination of ideas based on racial superiority or hatred, incitement to racial discrimination, as well as all act of violence, or incitement to such act against any race or group of person of another color or ethnic origin, and also the provision of any assistance to racist activities. So basically, under ICCPR, the International Convention on Racial Discrimination, Article 4, there are various types of speech that are prohibited. The dissemination of ideas based on racial superiority, the dissemination of ideas based on racial hatred, the incitement to racial discrimination, the incitement to act of racially motivated violence, the provision of assistance to racist activities, organizations which promote or incite racial discrimination, and of course, acts of racially motivated violence which are outside the scope of freedom of expression. Now, let's turn our attention to Article 20 of the ICCPR. Article 20 prohibits two kinds of speech. In Article 21, it prohibits the propaganda of war. And in the Article 22, it prohibits, and I cite, but it's on your screen, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence, and all of those shall be prohibited by law. This is a very wordy article, for many quite unclear. There are difficult concepts: advocacy, hatred, hostility. Altogether, this doesn't make for a very precise article. And then, of course, we have Article 19, and if you recall from the previous segment, under Article 19, some speech may be prohibited when, in particular, they affect the right of others. And that is, in particular, what is included when we talk about hate speech, the right of others. Okay, so many different provisions with different wording, with different kind of speech that are being included in the restrictions. Let me highlight a few differences between these various provisions, focusing in particular on the Convention Against Racism and the International Convention on Civil and Political Rights. So first, the Article 4 from the Convention on Racial Discrimination focus exclusively on racist hate speech, while Article 20 of the International Covenant on Civil and Political Rights include three types of speech based on race, nationality, and religion. So that's one difference. Second difference, Article 4 of CERD specifically calls for the criminalization of the speech it covers, in contrast with Article 20, which demands prohibition by law, doesn't say whether it should be criminalized, or indeed Article 19, which only calls for the legality of the restrictions. Thirdly, third general recommendation 15, which is basically the explanation for the Article 4. As stated, that the implementation of Article 4 requires not only the enactment of appropriate legislation, but the effective enforcement of such. In at least one judgment, the committee has somehow softened its stand by agreeing with state parties that, having criminalized racist speech, they have prosecutorial discretion as to whether or not to press charges in a particular case. It remains nevertheless the case that under Article 4, there is criminalization of certain form of speech. Yet one more difference between CERD and the ICCPR, and very controversially, is that Article 4 prohibits all dissemination of ideas based on racial superiority or hatred. And that is strikingly different from the speech that is prohibited under Article 20. The drafting of what became Article 4, in fact, produced some of the most contentious moments in the history of the process. There were many states that opposed the idea of prohibiting the dissemination of ideas based on racial superiority, including in particular the United States and the United Kingdom, but not only these two. So we have here a situation where under international law, various historical processes have resulted into different restrictions on freedom of expression and restrictions which are enunciated in a very different fashion. What you can see on the screen is a comparison of the various provisions, the type of speech that is prohibited, and the keywords for each one of them. And as you can see, they are quite different and distinct in the nature of the speech that is prohibited. Let's put that aside for a moment and focus on the regional and national system, and in fact we are going to add yet another layer of complexity. Under the regional instrument, there are different ways as well of dealing with hate speech and incitement speech. The American Convention on Human Rights does prohibit incitement to lawless violence or to any other similar action. But there is no case law, so the Inter-American Court has not dealt yet with incitement to violence. Please note that under the American Convention, it is only incitement to violence that is prohibited. It is not incitement to discrimination or hostility. The European Convention does not have any incitement provisions or any provisions related to hate speech. However, it has an extensive jurisprudence on hate speech and incitement speech. And those speech are excluded from the protection of the right to freedom of expression, or they are seen as violating the essence of the European Convention. The African Charter has no provisions on incitement and has very limited case law on hate speech or incitement speech. Under the national laws around the world, there are a wide range of prohibition of hate speech or indeed incitement speech. Indeed, those restrictions may be covered by constitution, criminal and penal code, anti-discrimination legislation, other laws, particularly administrative, and then there may be specific hate speech laws providing for civil and administrative remedies. And then if you add to that mix what's happening in the cyber world and the number of laws that have been enacted to deal with speech online, then you have even more laws, even more provision related to hate speech and incitement speech. So there is only one country maybe where there is some kind of coherence to the system, and it is in the United States. And it may be more coherent than in any other place because under the US First Amendment, direct and imminent incitement to violence is the only form of hate speech that may be prohibited under the Fighting Words Doctrine. So what does this doctrine mean? It was really first and well enunciated in 1942 by the US Supreme Court in the case of Sharplynskey versus New Hampshire. I'm not going to get into the detail of that case, but you can find it in your reading list. Under the US First Amendment, most forms of hate speech are considered as political speech, and therefore content-based and viewpoint-based restrictions will be declared invalid. Because they are political, it's very difficult to restrict them. Government may not regulate speech based on hostility to this speech or favoritism to other speech. This would amount to content or viewpoint discrimination. That's basically what the court said in Sharplynskey versus New Hampshire, and indeed it has more or less reiterated the same position since then. There are exceptions to this rule, and that's the so-called fighting words situation or fighting word doctrine. These are words which, by their very utterance, inflict injury or tend to incite an immediate breach of the peace. These are words which have a direct tendency to cause act of violence by the person to whom individually the remark is addressed. These fighting words may be restricted under the First Amendment doctrine, but no other forms of hate speech may be restricted. So where does this leave us? Can we try to make sense of it all? There is a great variety of definitions, of positions between and among regional laws, international law, and national laws. International human rights law provisions related to hate speech and incitement speech are also not inherently consistent with one another, and they are not very clear either. All we know for certain is that whether at the international level or at national level, some kind of hate speech can constitute a legitimate restriction to freedom of expression, and in some cases it is further narrowly defined to incitement speech. This is so because hate speech is said to undermine the right to equality, to undermine dignity, and to undermine peace and tolerance. In my view, international provisions and jurisprudence, and to a lesser extent what commentators and experts on hate speech have said, tend to show that there are different kinds of hate speech, and that it is thus possible to build a kind of a hierarchy of restrictions. It is clear from the Genocide Convention and the discussion at the time that incitement constitutes a particularly egregious or dangerous speech which is specifically named and defined and singled out for a specific intervention by the state. On your screen, I have drawn what constitutes, in my view, that pyramid of hate speech and incitement. And what you can see at the top are the incitement speech. Incitement to genocide, incitement to violence and possibly to terrorism, and incitement to discrimination. Those three upper types of speeches are prohibited under international human rights law, particularly the Genocide Convention, Article 20, and some aspect of Article 4 of the third, as well as Article 19. And then you have other forms of hate speech: vilification, glorification, promotion, justification. These are some of the key words that you may find in the International Convention on Racial Discrimination, but also in a range of national laws around the world. And finally, at the bottom of that pyramid, you have the hate speech that disseminate, propagate, or spread hostility. And they are different from those that vilify or glorify, because they really can be just mere avenues of dissemination as opposed to an intent to vilify or to glorify. So one way of highlighting the differences is on the pyramid or triangle that is now showing up on your screen, with the Genocide Convention at the top being the worst kind of speech and incitement speech. But then you have Article 20, which prohibits incitement. Third, the Convention Against Racial Discrimination, which also prohibits some form of incitement. And then underneath that, you have third again, which prohibits promotion and dissemination, as well as possibly Article 19 of the ICCPR, which prohibits any forms of speech that may be found to be necessary to protect the rights of others. So that is a way of making sense of the various kind of speech that may be restricted and which, with various differences across them, amount to some type of incitement or hate speech. I will end this segment by insisting on one thing. While incitement speech and some form of hate speech may be prohibited under international human rights law, we must insist that offensive speech are not to be prohibited. So there is, or there should be, a difference made between hate speech on one hand and offensive speech on the other. Of course, in practice, courts often find it difficult to highlight the differences between hate speech and offensive speech.